Good morning, ladies and gentlemen. I'm happy to greet you here at the St. Petersburg Second Legal Forum. And I hope it has become a tradition to carry out those roundtable discussions on mediation. Last year, launching the forum, we also had this kind of a roundtable discussion, and I hope today our discussion will be no less interesting. And I would like to thank the organizers of the forum for this chance to speak on the topic, on this very urgent and important topic in the legal practice and in the social environment. I would like to apologize for the lack of information you had, probably, because I know that some of the participants came at 9 o'clock. I hope they return. I hope they come back, because in the booklets of the conference, we were meant to have our roundtable discussion at 10:30. I hope everybody who is interested finds a way to attend this discussion. First, I would like to present our roundtable discussion members. We have speakers who have come from very far away, and I'll probably start in a geographical wise. We are welcoming Carmen Rice and Eric Green. These people can be called pioneers of mediation, both globally and in the US, and I'm very grateful they found the possibility to come over here. We thought that Ken Feinberg was going to come, a man who has done a lot in alternative dispute resolution and is still working on it very actively, and he being active prevented him from coming, because Ken Feinberg, if any of you know, he is working as a coordinator for the program on dispute resolution on the Gulf problem, or the oil spill problem, and he's mediating conflicts that resolve disputes connected with the oil spill. And as soon as this process is drawing to a close, he had no chance to come, but we have a pre-recorded speech by Ken Feinberg, and I think we'll be able to show it to you, and you'll hear his opinion on the importance of mediation. Other participants are Veniamin Fedorovich Yakovlev, and I'm also grateful he could come, because for many years he's been doing his best to make mediation and alternative conciliation procedures, to make them part of our legal environment, of our legal profession, and make them part of the social relations. We also welcome Evgeny Vasilievich Semeniaka, who is the president of the Federal Chamber of Lawyers of the Russian Federation, and since the early days he has been supporting mediation and doing his best to make the bar face modern tendencies and trends that we view in contemporary legal practice. And I'm also happy to greet our friend from the UK, Simon Davenport, who is a lawyer, and he asked for an opportunity to take part in our roundtable, to share his experience on using mediation and alternative dispute resolution. We also have several speakers who wished to take part, but they are probably coming a bit later, and we'll be happy to see them here. In any case, let us start our discussion. We'll do it as follows. Each speaker gets 5 to 7 minutes to make a statement and answer the question I'm going to ask, and after that we'll have a discussion on practical matters that have to do with ARS mediation, and everybody is welcome to participate. And my first question is addressed to Veniamin Fedorovich Yakovlev. It's probably a burning question. For a year and a half, we have a law on mediation, which is very good, and we never expected that from the moment it comes into force, everybody was going to use this practice. We know that this procedure will have to go a long and difficult way. But at the same time, we realize that we already have a legal basis, and we have a national organization for mediators that was founded by the Legal Association and the Russian Association for Entrepreneurs and Industries, and the legal profession, the legal expertise is working to train mediators, and will need education. But apart from the legal basis, we also need some state support for the mediation. To your opinion, Veniamin Fedorovich, apart from legal support, how can state support this institution? Thank you very much. I would like to make a few statements. First, conciliation and negotiation procedures, including those that involve mediators. We haven't been using this word, mediator, but it has been a tradition in Russia. Before the 1917 revolution, we used to have a system of arbitrary courts, and they were called so-called world judges, because their work was to provide conciliation. Before the revolution, Russia had a system of commercial courts, and well, this system was created in 1832. It was initiated by an outstanding Russian lawyer, Mikhail Speransky, and it took place here in St. Petersburg, in the capital of Russia at that time. And those commercial courts were used from had been used from the very beginning when considering claims that were issued by businessmen. So it was before court, pre-court procedure, and various conciliation procedures in the pre-court environment. During the Soviet era, various sorts of conciliation procedures were widely used. There were various labor commissions, labor dispute commissions, and obligatory conciliation procedures with divorce claims, and we also had various conciliation procedures to reconcile neighbors or colleagues at work. So it has been a longer, ongoing Russian tradition. Unfortunately, over the past 20 years, during this transition from one type of society to another, we have partly lost this tradition, and at present the society is in a state, in a conflict state, when introducing conciliation procedures becomes an urgent necessity.
You're aware that for many years I chaired the Supreme Arbitration Court, the higher court for commercial disputes. My late colleague, the former chair of the Constitutional Court of Russia, Vladimir Tumanov, used to ask me this question. You were the founder of the system of commercial courts. Why is it that you are so much involved in mediation? And I said my reason for doing mediation is because I created this system, and this is why I see that there is an extreme need to introduce conciliation procedures into so many different fields, including into commercial disputes. One reason for that is because this is the speediest and the most effective way, in many respects, to overcome various differences that arise between business people. And secondly, this is also a very good way to make the environment healthy, to normalize business relations. And as such, it serves as a foundation of fairness, honesty, integrity, culture, observation of the law, compliance with the law. These are the values that we all need to enhance in society. So what can the state do? Well, the state can do a lot of things. First of all, to create a legal framework for these procedures, to recognize them, and to provide a conducive environment for their implementation. This has been done already. A lot of this has been done. We spent several years drafting this legislation on conciliation procedures / mediation. So we now have that law. The next step for us is to really mainstream this within the business environment and in other sectors. And again, there is a very significant role that the government can play in supporting mediators, training mediators, in disseminating knowledge and practices in this field, in doing what I would call a good propaganda work in order to make this recognized. We have a lot of television stations and other mass media. How active are they in promoting these healthy conciliation mechanisms? My question is really addressed to you, our audience. The answer is obviously no, and then the question becomes why? Are they silent on this? Perhaps we should be asking the different government, the state institutions that are involved here, because a lot of television stations are government-owned. Perhaps private television could do a lot to promote these ideas as well. We could bring them on board also. In order to ensure that mediation procedures are implemented, three prerequisites should be met: the readiness of the parties, then the availability of skilled mediators, and the third prerequisite, the third precondition, is government support. So we need to be working on enhancing these three prerequisites, and it is my impression that the government is really underperforming a little bit in this respect. So I guess that the lawyers associations and other professional associations should contribute to this. I lead an association which has a good reputation and brings together a lot of different legal experts. I think we should really reinvigorate our efforts, and we should try to engage the government. This is why I'm so appreciative of the invaluable support of our foreign colleagues who are bringing their long-standing practices that they developed over the past years, the real masters of mediation. So thank you very much. We appreciate your interest and your engagement. Все. Нормально, нормально. Здесь. Thank you very much, Veniamin, for saying this, for saying that the government should intensify and broaden its support relative to the current level of support. But perhaps we should also be mindful that there is a need to maintain a balance here, because very often the government starts providing support, but at the same time they start interfering. Whereas here, we're dealing with a very fragile institution. So it is important to see the government really helping this institution to get underway, because it has to do with the government responsibilities to ensure access to justice as well as normal social relations. So I guess the government should recognize the advantages of mediation, but the government should also be delicate enough when they provide support to this new institution. Thank you very much, and it is now Eric Green's turn to speak. Just as I said, Eric Green is what I would call a mediation pioneer. We have met for the first time relatively recently, but in several conversations that we had, Eric said several times that conciliation is an evolutionary way to resolve disputes. It's another stage that humanity can achieve in resolving disputes. Eric Green was one of the founding fathers of mediation. The first textbook on mediation and ADR for law students in the US was authored by him jointly with Frank Zander. I guess some of you may know that the keynote address of Frank Zander at the Pound Conference in 1976 is considered to be officially the beginning of ADR being introduced. So Eric also was one of the co-founders of GEMS in the late 1970s, early 1980s. He has a very wide body of legal, theoretical and practical experience, and his practical experience is really very important. He's like a surgeon, like a doctor who needs to practice, and he also practices. So my question to you is, why is this important, and why is it that mediation is the evolutionary way of dispute resolution?
Thank you, Xian. It's an honor to be here to share thoughts with Russian colleagues, and everything the previous speaker said I share, and I'm delighted to hear. First, I think I'd like to share some basic principles with everybody that I think are not disputed. And it starts with the fact that just, efficient, fair, and respected conflict resolution is an essential element of a stable and prosperous and successful society. It is an obligation of sovereignty to provide these mechanisms for people. And the development and acceptance of law and the dissemination of law and judicial institutions are the foundation for a just, fair, and respected system of law. It's not an either-or choice between mediatory and adjudicatory processes, because just and fair conflict resolution must consist of binding adjudicatory processes provided either by the institutions of the state or created by the parties voluntarily themselves with private arbitration. But equally, just, fair, efficient, and respected conflict resolution may consist of voluntary and consensual settlement agreements negotiated directly by the parties to a conflict without any involvement by official, formal, or coercive adjudicative third parties. Now it gets a little bit more controversial, but in most cases, voluntary, consensual settlement agreements negotiated by the parties to the conflict are superior to binding adjudicatory decisions handed down by a third party, whether a court or arbitrators, no matter how qualified they may be, because voluntary consensual settlement agreements by the parties are usually more efficient, and so they're economically optimal. They allow for the full range of all possible solutions and maximize the possibility of shared gains, joint gains by the parties, win-win solutions. They're usually quicker and less expensive. thereby minimizing transaction costs. They mitigate and minimize risk, which is a desire of most commercial parties and indeed private individual parties. Direct negotiations provide greater party control and thus provide greater ownership and buy-in by the parties to the dispute. The results are more acceptable to the parties since they fashion them themselves, and that leads to more consistent implementation of the solution. And finally, consensual settlements promote future dispute avoidance and mitigation of disputes because they teach the parties how to resolve their own disputes. Now, third-party assistance is often helpful or required to facilitate these voluntary consensual settlement agreements between the parties. And that's because direct negotiations often fail. We know why they fail now. There's a limited list of reasons why direct negotiations fail. Poor communication, lack of information, the wrong people at the table, emotionalism, bad negotiation practice. And I've been teaching negotiation for 30 years, and the quality of negotiation practice, I'm sorry to say, is not improving that much. Linkage to other disputes, bad timing, and oftentimes sincere, good faith disagreement about their legal rights. What does a mediator add to the negotiation process that overcomes these reasons for failure? Very simply, a mediator facilitates better communications and opens up a new, safe communication channel. It gets the right people to the table. It assists the parties in obtaining and exchanging the necessary information. It controls and filters emotions. A good mediator helps coach negotiation behavior and prevent negotiation missteps. A good mediator designs and runs an effective mediation process. A good mediator helps the parties objectively evaluate the no agreement alternatives by predicting the likely legal outcome. A good mediator provides the focus and energy for resolution. A good mediator will serve as a lightning rod or a scapegoat for parties who are dug in to entrenched positions. A mediator might help implement the settlement by certifying compliance and resolving follow-on disputes. And a mediator can supply his or her specialized dispute resolution art and technology to get there. The state, courts, executive, legislative bodies may do many things to foster and establish high-quality mediation institutions and practices. First, it should permit and encourage negotiated mediated conflict resolutions because they're often superior. I understand your new law is serving that function. The state can help educate business people, lawyers, judges, and officials about mediation and other forms of ADR through forums such as this. And the state can help establish and support private and public mediation institutions. There's an interrelationship between adjudication and mediation processes. Formal adjudicatory bodies like courts and arbitration and informal mediatory processes both have their role in a modern, pluralistic, vibrant society. Do not sacrifice one for the other. You need both. Courts fulfill an essential function, and they play a unique role in the modern dispute resolution system. Courts articulate norms. They say what the law is, even if in between the spaces of the civil code. Courts are there to constrain those who do not act reasonably consensually, and there are such persons and institutions. Courts are a check and a balance on other institutions. Courts assure private entities, public officials, and the common man of the rule of law, and they provide the backdrop against which informal mediatory processes can operate. Mediatory processes can resolve most disputes faster, more economically, better outcomes, and with greater party satisfaction than can courts. And they take pressure off the court system allowing the courts to handle the disputes that are needed. I think conflict resolution is an essential attribute of species functionality and survival. How a society handles conflict plays a vital role in its success or failure. And I think conflict resolution is subject to evolutionary forces and theory as are other phenomena. I think if you look at the long passage of human history, you can see three stages of conflict resolution. Stage one, the most primitive, was retributive. It focused on an eye for an eye and a tooth for a tooth conflict resolution. It dominated the prehistorical and primitive stage of human evolution. Stage two is the adjudicatory phase. It involves courts, trials, proofs, arguments, judges. The first recorded trial in Western literature dates to 458 BC in the third book of the Oresteia, when Orestes is tried before a jury of the gods for the murder of his mother Clytemnestra. That results in a hung jury, which results in an acquittal. And it initiates the current phase of modern dispute resolution, which has lasted nearly 3 millennia. Why do we think that's the end evolution of conflict resolution? We're constantly evolving into more progressive and better forms of behavior. I believe we are on the cusp of a stage 3 of conflict resolution, which is based on consensus and agreement. We'll use mediatory processes, and I think it is imperative that we evolve to this stage 3 in international, environmental, commercial, community, and interpersonal dispute resolution. Evolution is not a quick or smooth or uninterrupted path. There are fallbacks, there are difficulties. The essential question is, how do we evolve to stage 3 while preserving the necessary protections provided by stage 2? That involves a careful balance and nurturing of both forms of dispute resolution, the adjudicatory and arbitral on the one hand, and the mediatory and negotiation-based processes on the other hand. I'm pleased to be involved in both phases and a part of the movement towards stage 3. Thank you.
Thank you very much, Eric. And indeed, we are viewing a process when mediation on the national level, not only on the national level, but also in various countries, it is becoming a tool of international dispute resolution. And I'm happy to pass the word to Simon Davenport. So you have 7 minutes for each speaker. Simon asked us to let him speak now because he has to go to another roundtable discussion, and we'll be happy to hear him.
Большое спасибо. Сусанна, я думаю, что меня слышно, потому что это непросто. Но сначала я хотел бы сказать 2 вещи в начале. В отличие от других выступающих, так же, как и другие выступающие, для меня большая честь здесь участвовать. И
hopes will become the Davos of legal discussions around the world shortly. The second thing is I very much recognize the steps that have been taken typically quickly by the Russian Federation to put in place an effective, fast-growing effective system of mediation, especially strides taken since 2004, and our esteemed moderator has played a very large role in that process, having read her papers done for the Council of Europe and the European Parliament, which are very effective. I want to cover, in my short little time, about 4 different topics. This is from a UK perspective. I'm a barrister, a QC, operating in London, and therefore I'd like to bring to you, essentially a Russian audience, what happens in the UK and our experiences, which I have to say, from my point of view, are almost entirely positive. That doesn't mean that every case leads to a settlement in every particular mediation, but I have had very large success rates in this process, and if it hasn't led to a settlement immediately, then it has led very often to settlement further down the line. I echo everything that Eric said. So I'm going to talk about the process itself, which might be interesting to those who don't know and routine to those who do. I'm actually going to talk from the other side, abuses of the ADR system. And then thirdly, I'm going to talk about the interaction between the UK courts and the mediation process. And fourthly, I'm going to talk a bit about choosing a mediator. And like any other arena, there becomes quickly skill sets in deploying yourselves as parties within a mediation process. And you need these skill sets to get the best result you can. So first, the process itself. This, of course, is just one form of ADR, but one of the most effective forms of ADR. The first important thing is timing. When do you choose to suggest a mediation or to accept the suggestion of a mediation? Can you be wrong-footed by accepting a mediation too soon? Some types of case start because some types of claimant feel that they are outside of the information process. Take, for example, a shareholder who's a minority shareholder, feels he's being taken advantage of and can't get any access to the information that the board of directors are keeping from him. He can't just turn up to a mediation process. He needs information. Looking at a case called O'Neill and Phillips in the House of Lords, the nature of a settlement of a shareholder's dispute must incorporate a level playing field, meaning an equal sharing of information. So the first issue is, it may be that you have to wait a little bit later before you will get to a mediation process. You can't just have it the first available opportunity. The second thing is the preparation is very important for the day. You have to choose your mediator. I will come to that in a moment. You have to prepare position statements which summarize your case. Then you have to choose carefully your representation. You must have visible somebody who is an authority figure. This is a very important process. If a party turns up to a mediation with no visible authority figure, it can be deemed to be an insult or a recognition that there's no serious intent on the part of one particular party. The next thing, I've learned this, having conducted hundreds of mediations myself as an advocate, is that showboating, I don't know how that translates, showboating to please your client is increasingly a counterproductive measure. The more moderate and reasonable approach is more likely to lead to a better resolution, and may I say, at a better price and on better terms for your own client. 2 anecdotes, if I can. I turned up to a mediation as an advocate for one party, and after the careful preparation put in, the managing director of the company against us wagged his finger at my managing director of my company client and said, "If you think you're getting a penny out of me, you've got another thing coming." This is not the right approach to start a mediation. Secondly, rudeness. You can bare your soul and get things off your chest, but rudeness has no place in a mediation. It will lead to counterproductive time. Then, of course, you retire after a plenary session and the real negotiations start. This may or may not involve the protagonists actually speaking together, something they hadn't been able to do perhaps until then. And then there are, of course, the skill sets I talked about in extracting the best terms. Hopefully, you reach a settlement. One watchword about this, a lot of mediators want to get the whole thing wrapped up in writing and signed off that day. Many of these settlements are happening about 10, 11 or 12 o'clock at night. We don't want to turn mediations into professional negligence actions. And I've witnessed lots of pressure being put on parties to sign off agreements when in fact it's more prudent to think about it for a little while. The second topic I want to talk about generally is abuses of ADR. Now, uses and abuses of ADR. It's important to recognise that there can be abuses of ADR and not to encourage this from an opponent. Essentially, usually it should be said from defendants, who are ultimately more likely to be a paying party. Thereafter, collateral information, resources to test your will or your strength of purpose, to see whether the spirit is strong, to test what your commercial imperatives are. Some of the worst examples of abuses of ADR have actually been the preparation and conducting of mini trials within the ADR process. Sometimes a good idea to get to the heart of issues, can be misused in certain circumstances if underlying this there's no intention to settle at all. My third big topic is the UK courts. Is it or is it not encouraging of the mediation process? The answer is emphatically yes. Since 1998, there was a big procedural review in Britain, the CPR. That has led to virtually every stage of the process being open. The old days, you were able to keep your case under wraps until later. Now, you have to do a pre-action protocol process, which means exchanging your full case in correspondence before you start an action. You have to set out your case fully in pleadings. You have to give disclosure, all your documents, fairly. You have to exchange witness statements fairly. Experts have to limit what they're going to be disagreeing about fairly, all well in advance of a trial. So it stands to reason that there is a great desire by the court, wherever possible, to see if the parties can settle cases. Accordingly, the courts are very willing to encourage parties to mediate towards settlement. There are two particular aspects to be remembered. One is that the court will, from time to time, grant the party a stay of the process to explore possibilities of settlement. The second process is the punishment that might follow for a party that unreasonably refused to enter the mediation process. This is an interesting area with quite a lot of law. It's always applicable to when the party that didn't turn up to the mediation process wins the case. It will turn around and say, well, we won the case, the other side were unreasonable. But there have been cases whereby different orders from the normal cost orders have been made. And so lawyers will tell their clients quite properly that there is a certain commercial pressure that can properly be applied to the opposing party by insisting that a mediation process takes place. The last topic I want to talk about is choosing a mediator. Now, who do you choose? Do you choose somebody who's an expert in your field? Or do you choose a stranger? And I think there are valid arguments for both. I should be interested to hear what Eric has to say about this. You could choose a specialist in your field, but the history of litigation, going back to cases like Fox and Welfare in 1925, shows us that when you have somebody who's absolutely an expert in a field, they can't help themselves but start to impose their views and start to think they know better than the parties in front of them. And therefore, one's got to be very careful. The other thing to remember is that mediators get judged on just one thing. Sorry, two things. Their usability, but secondly, how many cases they settle. So you have to think, who is the mediator going to put most pressure on to do the deal? I used to think that defendants got a better deal in mediations because it was always easier to put pressure on a claimant on price. and you could always talk a claimant's case down. I think I can see the other argument, but it's a point for a user of mediation services to be aware of. I don't know how I'm doing on my time. All I would say is that the court cases that have come to mind, the topics, are these issues. A stay. Will the court actually impose a stay and order mediation? I've just been in the arbitration room and hearing how the Chinese have an obligatory mediation process, which I wasn't aware of, before you get to a Chinese arbitral court or indeed an appeal from a Chinese arbitral court. That is not the case in the UK. The court might strongly encourage that mediation take place, but it won't order it. It might order that a stay takes place, but it can't tell you to turn up to the mediation process. All it can do is the second topic, costs, to look at that. I've already talked about costs. So to punish a winning party for unreasonably refusing to turn up to a mediation. Unreasonable might be in the circumstances not engaging with the process. That is very fact sensitive. The third issue is waiver of privilege and confidentiality. Now, the confidentiality is largely, essentially contractual confidentiality, and is also without prejudice nature to the process itself. Now, there have been one or two cases in England where there has actually been the loss of that precious commodity confidence, and it's usually been on the facts construing that the parties had waived their rights in confidence. Of course, poor old mediators are under a duty of continuing confidence in respect to the process itself. And what happens, for example, where you've had claims against mediators, dare one say, professional negligence actions against the lawyers conducting the cases themselves. These are all interruptions in the confident process. So I'd like to end by saying thank you very much indeed for participation here. I congratulate the organisers of this wonderful conference, and I'm privileged to share the stage with such luminaries as I have to my right. Thank you.
Thank you, Simon, and спасибо, Simon. И действительно.
Yes, indeed. It would be highly interesting to hear from a lawyer. Always interesting just to see how a lawyer sees the mediation process. But it would be just as informative to hear what the difference is between a lawyer in a competitive process, adversarial procedure, and my colleague here said that he has mediated hundreds of cases. He did not specify which particular role he played, because as far as I understand, in those situations, Simon was accompanying his side through a mediation procedure. So it would be highly interesting for us to learn about this major difference. Before Simon goes, I would ask this question. What does it mean for a professional lawyer to be part of this cooperative rather than adversarial process?
It's a very good question. I think it's been a learning curve. I think the temptation for lawyers who are new to mediation is to treat it like litigation and to go in, good English expression, all guns blazing. I've learnt to realise that that is not usually the best way to obtain a good result for my client. And I found that the moderate approach, the strong but moderate approach, is the right way. I think that starts right at the outset by choosing a representation, and also by your drafting of your position statement. If it is designed to irritate the opposition by highlighting certain aspects about which they're already easily irritated, you've already put your client's chances of settling it back. So my own view is you will always know with your client what price you're either receiving or paying, broadly speaking, and as long as you're strong in your own conviction, you should have no difficulty in being able to be very pleasant about the process leading up to it. And that quiet strength, I think, is the key to mature success in the mediation field from the point of view of representing one of the parties.
Спасибо, Саймон.
Thank you very much, Simon. Just one more question before you go. Simon, do you always inform your clients about the availability of out-of-court processes and options when you start working with a client, or do you usually decide yourself, and once you have decided for yourself, you then decide whether to inform the client about those options or not? That's what I'm interested to hear.
Yes, very good question. I think the role of a lawyer is to inform as early as possible your client about all of the possibilities of reducing cost, of being able to get to an early resolution, or maximizing chances. For example, you may meet your client or your client's witnesses and realize that they are not going to make good witnesses and that their case is not going to do so well if it ever does go to court. This is an important piece of information because it's something to be weighed up when advising the client what the best strategy is. Or you may have, as I have had, individuals who simply tell you that they can't stand the process of litigation, that they never wanted to have to resort to litigation, but that they implore you to do all that you can to try and terminate the process as early and as peacefully as possible to get a reasonable resolution. And that doesn't just mean little people, that means sometimes very large corporations who have reputational interests to protect and do not want to be embroiled in a long, bloody battle which leaves few survivors and no victors.
Спасибо. Спасибо.
Thank you very much.
And now I'm happy to give the floor to Carmen Rice, our guest from the United States of America, from Massachusetts, where she, apart from being a mediator herself, is also a member of the City Council. And in fact, as Carmen has explained to me, she could combine two posts, this post with this position with being an active mediator. But you have to be very, very careful not to avoid conflicts of interests. Carmen has spoke a lot about how important it is to use mediation on the regional level when resolving disputes between city authorities, for example, and a community. And I'm happily passing the floor to her.
Thank you. I'm very pleased to be here with all of you at this wonderful conference and to share with you my experience in 20 years as a professional mediator and more recently my experience as an elected local government official. We've talked this morning about the things that government can do to foster the use of mediation in the private sector. But government can also itself use mediation, both for disputes in which it becomes embroiled and in the course of carrying out its duties. Government is charged with providing infrastructure, managing resources, balancing the interests of people and businesses, and balancing long and short-term goals. Conflict is inevitable, and it seems also that budgetary pressures are also inevitable for governments everywhere around the world. Mediation offers an opportunity for creative dispute resolution, the kind of resolutions which can result only in winners and no losers, whereas an adjudicated result may produce a winner and a loser. That means that these kinds of results to conflict, resolutions to conflict that are achieved through mediation will be more likely to preserve relationships, and relationships are, after all, the basis for community. As Eric mentioned earlier, and Simon, it also offers mediation, the process that can result in a resolution at lower cost and with less time. Governments can use mediation or mediated processes before their own decisions are made. It can itself act as a facilitator, gathering together the right people, getting the right information out, and finding the right process. It can use mediation after decisions are made if there are citizen disputes or business disputes about the decisions which have been made. And it can also use mediation to resolve disputes that arise out of any kind of normal operations that a government has. A government may, for example, construct roads or buildings and find itself in a dispute about the construction or the costs or the quality in those projects. In short, mediation can be used by governments for the largest of disputes, say, for example, disputes over water rights between agricultural users and residential users in an entire region, to the smallest of disputes, say, for example, barking dogs that are annoying their neighbors. And it is an excellent tool, and it is useful for governments to use and useful for governments to have, for their individuals in government to have training in dispute resolution so that they can use mediative processes and mediative tools in carrying out their responsibilities.
Thank you very much, Carmen. And now I would like us to see the screening. We got the pre-recorded speech from Ken Feinberg office. He made it in haste when it was decided that he was not able to come. But in any case, I think it will be of interest to everyone because he's telling about how he resolved disputes connected with 9/11 and also other big, large disputes that had to do with environmental disasters like the BP oil spill in the Gulf of Mexico. Before that, I would like to comment upon the speech done by our British colleague. Indeed, Lord Woolf, reform. As soon as you're ready, just tell me with the screening. I'll just make a comment that Lord Woolf, reform has indeed implemented huge changes and has catalyzed the process of mediation introduction. But our lawyers and our state officials and well, many people here say, and they have a right to say that our litigation is not as expensive and as long-term. But it's important to to see the steps that the British government and the British Department of Justice takes to introduce mediation. They have a national hotline which is active since 2004, which helps to resolve thousands of claims through mediation. And recently, the Ministry of Justice has passed a decision, together with the Council of Civil Mediation, to launch a pilot project according to which all appeals up to £100,000 will have to be resolved through mediation. They will be resolved through mediation with the participation of the CEDAW mediators, and it will probably help to integrate this procedure into all appeals. And now let's listen to Ken Feinberg, who is approaching us from Washington, D.C. I want to underline that Ken Feinberg is a man who, from the late 1980s, has been working with the judicial system, and he has acted as a special master in various dispute resolutions. We're ready
for your exciting and informative conference. Unfortunately, the press of business keeps me this week, the week of the conference, in Washington, D.C. But I welcome the opportunity, just for a few minutes, to explain to you some of the more challenging and interesting mediation work that I've done over the past 25 years here in the United States. Every once in a while, there is a tragedy that so involves the entire nation here in the United States that the conventional way of resolving the disputes in the courtroom with judge, jury, and lawyers, our policymakers decide that there ought to be a different, more creative resolution of the tragedy. It might be a judge that appoints me to mediate a settlement and a claims process. It might be the Congress of the United States, which 11 days after the September 11 terrorist attacks passed a law creating a voluntary optional compensation program. Or it might be the President of the United States, who sits down with a giant oil company like BP after the tragedy and the oil spill in the Gulf of Mexico in April of 2010, and together with BP agrees that there will be out-of-the-box thinking, that there will be a claims compensation program involving mediation rather than traditional litigation. I have been involved in many of these unique situations where a mediated settlement and a claims compensation program is established as an option for victims to consider rather than go the traditional litigation route by asking judge and jury to resolve the claim. All of these programs, Agent Orange involving Vietnam veterans exposed to the defoliant while serving in Vietnam, the 9/11 terrorist attacks, the shootings by a deranged student gunman at Virginia Tech in 2007, the BP oil spill, and I might add, by statute, my role in fixing the compensation for corporate officials who served at those companies in the United States that needed the most taxpayer assistance to stay out of bankruptcy in 2008 and 2009. In all of these cases, policymakers decide that instead of lawsuits, let's try consensual, negotiated mediation. And in every one of these cases, beginning with Agent Orange, right through BP, we have been able to resolve the disputes, determine the compensation, get people paid without going to court. The situation arises in the United States whether or not these particular unique situations where mediation is used, whether these are the wave of the future, whether we will see more and more mass tragedy or mass complex litigation resolved not by going to court, but through these special mediation programs. I do not believe so. I do not believe that these programs are a precedent for anything. They are a unique response to particular tragedies that so galvanize the American people and their elected representatives that a new program, consensual, optional, voluntary, is established. But I don't think that it is the wave of the future. I think that the creation of these programs is few and far between, so rare as not to be likely to be replicated. And I think it's probably a good thing that they be not replicated. Bad things happen to good people every day in the United States and around the world. And in the United States, every time something bad happens, you don't have a special mediated compensation program to compensate victims. I think it is problematic to say, for you victims of the oil spill in the Gulf, you have special compensation not available to anybody else. To you victims of the 9/11 terrorist attacks, you have a special procedure not available to anybody else. So too Agent Orange, so too Virginia Tech. For you corporate executives who will have your pay fixed by the mediator, only your pay, not anybody else. It's a problem in a society where the law is designed to govern all, not just some, to have a few people subject to these new rules and these new procedures, while everybody else lives by the old rules. Now, in all of these programs that I've mentioned, beginning with Agent Orange and going right through 9/11 and through BP, even though every one is different, even though the circumstances, the context is different, when the mediator sits down to deal with the parties, the victims, and in some cases the defendant companies, the same issues arise. One, who is eligible to benefit or be subject to these programs? Who is eligible You have to define the universe of people that are subject to these programs. Eligibility is a critical first step. You are eligible, you are eligible. You are not eligible. You cannot participate in the program. Eligibility is the first issue that the mediator must resolve, especially in a mass disaster, oil spill, explosion, terrorist attack, mine disaster, floods, hurricanes, blizzards. Who is eligible to participate in the program? Second, what will be the methodology used to calculate damages? If you're going to pay a victim, or you're going to pay a corporate executive, what is the transparent methodology being used so that everybody knows in calculating damages, even if you're eligible, in calculating compensation, if you're one of these corporate executives, here's how the mediator will do the calculations. 3, what is the level of proof required for a claimant to come forward with a valid claim? What do they have to show? Do they have to present tax returns, profit and loss statements, checkbooks? What do they have to do to corroborate, to prove their claim, even if they're eligible, so that the mediator will know how to calculate the damages? 4, will there be a hearing? Will every claimant, even if eligible, have the opportunity to come in and see the mediator and actually participate in a mediation surrounding her or his claim? It is easy to do a hearing when you have very few claimants. When you have over 1 million claimants, like I did in the BP oil spill, a hearing is not practical. When do you permit the claimant, the individual subject to your determination, when do you permit that person a face-to-face opportunity to meet with the mediator? Next, if the claimant mediates a settlement and accepts the dollars that are offered, what rights does that claimant relinquish? In 9/11, if you accepted any money from the special master mediator, you waived your right to sue. You could not go to court. You didn't have to accept it, but once you accept the money, you waive your right to go to court. So too BP. If you accept a final payment for your damages arising out of the oil spill, you waive your right to payment. Very important issue in America. If you take the money, what do you give up in return? And finally, a very important question. Who is going to pay for these claims? In 9/11, it was the federal government, the taxpayer. This was all public money advanced by the taxpayer. In BP, BP decided to put up $20 billion to pay claims. You've got to decide very quickly in these mediations who is going ultimately to have the responsibility for funding the program. These are all the basic issues that arise in these mass claim mediations that I've been involved in over the past almost 30 years. I think they raise some interesting issues, public policy issues, issues pertaining to fairness, efficiency, speed. They are particularly important in the United States, where the alternative is traditional litigation. I hope I've added somewhat to your program. I hope next year to be able to appear in person. I hope that this brief videotape has proven useful, and I thank you all very much for permitting me to participate by high technology. Thank you all very much.
Ну что,
Well, we thank Ken Feinberg, and I hope it was interesting and informative for you. But I would like to also make one remark here. Ken Feinberg is not a mediator. Ken Feinberg is a brilliant lawyer and legal expert. This is a person who, for the duration of his entire professional career, has always abode by the highest standards of ethics. I'm sorry? Is everything fine? Is everything all right? Okay. So I would like to say that it was not accidental that at the ABA conference a month ago, Ken Feinberg was celebrated as the best lawyer. He got an award which is difficult to translate, really. He was awarded Best Lawyer Problem Solver. So this is a legal expert, a lawyer who knows how to solve problems. Let me give you another example. During one of our conversations, he told me a story about how he had resolved disputes related to the 9/11 events. Of course, there must have been a lot of emotions involved into that process because he was dealing with people who had gone through a terrible tragedy in their lives. And this is the story that he told me. He said that initially he would invite those clients of his into his office in order to hear them out. So he was prepared to hear about financial claims, compensation claims, and so on and so forth. But as a result, he had an office full of videotapes, photo albums brought by those clients. So every morning would start in the following way. He would receive a client and he would ask the client, "What can I do for you?" And that person would say, "You know, I just wanted you to see the photos of my wife, what my son looked like, and what my brother looked like." So they would sit down together and watch those tapes and look at the photos. So there was a lot of sharing on the part of the clients, and he said that for me the sharing was the most important thing. Sometimes people said, "I don't have a claim, I have a $0 claim," because nothing would be able to compensate me for the loss, for the bereavement, and for the tragedy that I have experienced. So thank you for letting me share with you. So he said that in that period of time I had to really attend the opera at least 3 times a week, because this was the only diversion I had. This was a place where I could just sit silently and sit quietly and sometimes doze off during the opera. This is a person who is very assertive, and Eric knows about this. Is a highly pragmatic and results-oriented lawyer, but he is a good lawyer. He uses his mediation skills to achieve his work goals, and when he talks about the BP case, it was not really only about mediation. Of course, he had a certain budget to expend. Now he's managing a lot of money, and there is a great debate going on in the US whether or not he can be really impartial in this situation, playing that role, because one way or another he's playing on BP's side. But In my opinion, for the modern lawyer, mediation should never be a competitive adversarial process. They should use mediation tools. They should have mediation skills. They should be educating their clients about the potential of mediation, the opportunities. When we drafted the Russian law on mediation, we made a very clear provision there to the effect that even if a mediator is a lawyer, they do not have the right to advise his or her their clients on legal matters. And this was done intentionally because any such professional advice may impair the mediator's impartiality. And because mediation is still a very fragile institution, we decided to introduce this provision. There is also a consequence of that. We do need mediators with lawyering skills, because legal consultations will be necessary in the process. And this is why I would like to turn to Yevgeny Semeniakov here. He has always been supportive to us throughout the process, and I believe that there is really a cohort of lawyers in Russia these days, lawyers who are loyal and committed to mediation. But in the legal community, there are still people who believe that mediation is a rival to the traditional litigation. So my question to Evgeny is this: how can we make good inroads into involving lawyers into mediation in this country? So please, Evgeny, turn on your mic. Thank you very much, Susanna. Dear colleagues, unlike the previous speakers, I would like to confine my presentation to the legal aspects. I'm not a mediator, really, in my professional life. Well, that doesn't mean really that I do not have a position, an opinion about mediation, because I think mediation is a remarkable institution. It is an awkward term for the Russian ear, a foreign term. So it was not accidental that Veniamin, when he opened this discussion, used a different term. He talked about conciliation procedures, conciliatory approach. I think at the end of the day, it's just a matter of taste, which word you use. We don't want the discussion to really involve any debate over terminological differences. But let me now go to the crux of the matter. This round table, this group of people came here today to discuss mediation as a set of tools, specific strategies. This is what most speakers talked about. They shared with us the different do's and don'ts for the mediator, and this is only logical, really, for my esteemed foreign colleagues here. Mediation is really part of their business as usual when they resolve disputes. As a matter of fact, when my esteemed colleague sitting next to me says that today mediation is even used in government to resolve various conflicts in order to develop balanced and fair decisions, one can only wonder when will we be able to overcome this misfortunate time gap between those countries and ourselves in terms of introducing mediation. But I think it would also be useful to remind my colleagues here about the different prejudices that we had to overcome in the legal community to get the law underway. Initially, the authors, the developers of the law on mediation excluded lawyers from the range of individuals that could be involved in mediation. This didn't happen. This is not in the law, and I think this is mainly thanks to Tisana's efforts. I believe Tisana is really a powerful idea generator on mediation in Russia, and this is also an enthusiast who has been able to see her ideas being implemented in practice. She dedicated several years of indefatigable work, several years of her life to get this discussion started in Russia to explore mediation. Therefore, I think that it would be extremely useful that if we, giving due respect to the practical experience which has been accumulated by mediators in Europe and in America, also tried to define the exact time and place of mediation in Russia. Where are we in terms of mediation? This is just an observation. I think we have a very good law on mediation. This is just my opinion. This is an opinion which is also shared by a great many colleagues of ours abroad. Today, Russia has an association of mediators. This is also a very important institutional achievement, because from very early on, you should try to develop common standards for all people who decide to work in this field. They need to share the same professional and ethical standards. You need to make sure that these standards are not just declarations only, but that they serve as very practical guidance for these people. So both the legal and organizational framework, although available, are not sufficient to, if you want to mainstream mediation in this country. Because you may have noticed already, based on the discussions that we had previously and today on mediation, especially when you bring on board people from the judiciary, judges, there is a tendency to view mediation as a sort of a supplement to litigation, as a way to avoid court proceedings, to avoid litigation. But when I was listening to my authoritative colleagues from abroad today, I thought that mediation can be viewed as a universal tool, as a tool that can help with almost any type of dispute. Perhaps it's also a preventative method. It's a way to avert a conflict. Also, I think that we tend to overlook these different dimensions of mediation. But as a lawyer, what can I say about mediation? What value it creates for us? I believe that we as lawyers should primarily try to raise the awareness on mediation as much as possible in the legal community. We need to convince our colleagues that mediation opens up a lot of different avenues for us in our lawyering practice, because for some lawyers it's just an extension of their legal work, but this is not so, and you need to educate people about that. It's very easy to see that it's not the case by simply listening to some of our colleagues who were able to demonstrate to me very clearly today that even though the mediation procedure may seem very simple, it does require special skill sets and special strategy, and once you have mastered these strategies, only then can you pretend to be effectively practicing mediation. I think the legal community, the federal chamber, the regional chambers should, as a second step, ensure mass training in mediation across the country to develop those skill sets. Together with the association, the Federal Chamber of Lawyers, has instituted a new thing, although we cannot really boast any major achievements, but what they did was they went ahead and created a center of mediators. We do believe that this is going to be a center of excellence to train mediation experts. This is not only going to be for St. Petersburg. Let me tell you that we already have a center dedicated for training. Today, St. Petersburg already has a relatively small group of lawyers who can claim that they have mastered the basic skills of mediation, and they have been awarded certificates that entitle them to practice mediation. Well, these are some of the early birds that we have within our legal community. But, you know, when we in Russia talk about early birds, we say that an early bird does not really make the weather. I don't think this is the case with respect to these people, because they are already changing the climate, the environment. They are the agents of change, and they will be able to sensitize and incentivize the legal community. Let me also tell you that Moscow these days already has several legal or law firms, let's call them that, already offer mediation services. I'm not going to advertise them, so I'm not going to give you their names, but as a chamber representative, I'm aware of at least 2 law firms in Moscow that are doing mediation already quite successfully. I believe that mediation is a field where there can be no monopoly indeed. Mediation is a field that calls for a wide range of offerings. I would like to add something here also about government support. The government support which was described by my colleague here, by Veniamin, government support that was also described by Ms. Rice. It should not be confined to a general acceptance of the state or non-interference of the state. I think there are many more effective ways that the government can in which the government can support mediation. For instance, my colleague Rice here said that one thing the government could do would be to introduce mediation even into those sectors that are traditionally outside the judiciary system. For instance, mediation in the work of the government, mediation to resolve disputes between different players and agents which are part of the civil service. This is another way to disseminate mediation, to present mediation as a preventative tool, a tool that even helps to prevent social conflict. However, for us, as lawyers, another aspect of government support is highly important, namely the legislative role of the state, the ability of the state to introduce not only general legislation, but also more detailed enabling legislation. Unfortunately, I don't think that in this country we have that many incentives to apply mediation in arbitration or in criminal proceedings and in such areas as family legislation and labor legislation. And there is a wide range of opportunities to use mediation here. So from that standpoint, I believe the legal community of lawyers in this country is challenged with the task to put forward some specific proposals especially that we can now do that through the Mediators Association, especially that we can also initiate amendments to legislation on the basis of our effective cooperation between the Association of Lawyers in Russia and the Chamber on the one hand, and the committees of the Duma, such as the Legislation Committee, the Constitutional Legislation Committee, and the Government Development Committee at the Duma. Let me tell you that today we have a plethora of different opportunities to take Russian legislation forward, to initiate changes and improvements. So my last message to you is, please have appreciation of mediation, implement mediation in your professional life, recognize the potential of mediation. I hope that very soon in the US they will be inviting Russian mediators to share their experiences to the professional mediators community in the United States. So I'd like to leave it there on this rather optimistic note. Thank you, Evgeny. Well, first I would like to say that we are getting invitations already, and we have been getting them for several years, because I am a fully fledged international mediator. But yes, we would like more invitations to come for a wider range of people. Okay, let me really catch you on your word here. You said that government support is vital, and yes, indeed, it's vital, but there are things that where we can help ourselves, don't you think? As a first step, we might undertake the following. We might use some of the existing practices, for instance, US practices. For instance, the Code of Conduct for lawyers in the US says that lawyers must inform the competent parties on the availability of mediation and other ADR procedures. Perhaps one thing we could consider introducing into the Code of Conduct of Lawyers would be exactly this provision, but we need to take this through the entire legal community to discuss this beforehand, so that in the end lawyers can better inform their clients and enable their clients to make an informed decision to do mediation. I'm sure that very soon we will be building a body of practice which will also help lawyers to accompany their clients through the mediation procedure, because this needs to be done professionally, and there are certain skills involved. Perhaps we shouldn't really limit ourselves to the lawyers community only. I believe that in most codes of conduct for most legal experts, it would make sense to introduce such a provision, not just an incorporated provision, a declaration there, but make sure that that provision is observed by these different legal professions. So thank you very much, and I think I agree with you when you say that there should be some lawmaking initiatives put in place to take this forward. And it's not accidental that Dmitry Medvedev, our Prime Minister, our ex-president, in his address as of December 2011 said that we should consider the possibility of introducing mandatory ADR procedures, and I think already now we can say that our efforts have not been in vain. Some 5 years ago, if the President had addressed the legal community with such an appeal, it would have been very negatively received. But now the Supreme Arbitration Court and the Supreme Court both are highly supportive of this. The Supreme Court has even identified a typology, several categories of cases where they will be asking for mitigation. They are prepared. It's just that we may not be prepared. The mediators community may not be prepared.
We have a huge country. To say that mediation is to become obligatory. We need to give each citizen a chance to receive or to undergo this procedure, and free of charge, at least to a certain extent, which means that we're facing a question. This is something we should prepare ourselves for. On the other hand, we should probably be more active, or as active, that this introduction of obligatory mediation will not, it will become part of our culture. We won't need this measure to be introduced. But if today we introduce mediation as an obligatory measure, we prevent access to fair legislation, to fair, and you have a lot of examples of that in the United States of America, when parties have a chance to go through a mediation session for 2 or 4 hours free of charge. But for that, we need to have as many mediators in all our towns and cities, where we can pick proper mediators or well-experienced mediators who will be able to carry out those mediations. This all requires a very well-thought policy from the state, and it will happen in due time. What we need is our joint effort, and I'm grateful for the comment you made. Thank you. And I hope that we'll discuss those questions, those issues, and we can pass over to this kind of discussion. If anyone in the audience, let us follow the following scheme. We have 2 comments or questions per each issue, because we have some time left to move forward and perform our minimum program. Gleb Sevastianov, Arbitrary Code magazine editor. After what Tisana Avtantilovna said, speaking on the discussion on the obligatory mediation being introduced, I wouldn't be as optimistic. Even on the level of the Ministry of Justice, this suggestion has been reviewed and it received negative assessment. I think we should have a discussion here as well on the possibility of using mediation. This term, obligatory mediation, is it possible theoretically or practically? Can we use it, since mediation or conciliation procedures without regarding the will of the parties? I think it's a judicial fiction. We need to define whether this procedure is possible. What can mediation consist of? We should probably encourage, the mediator has no right to make parties take this or that decision. It's an attempt, this attempt to, should be fixed somehow, this attempt to resolve to mediation. And I'm asking our foreign guests, both Eric and Karin, to tell us about their experience and probably share their opinion on the obligatory nature of mediation. Should it be obligatory?
I have concerns about making mediation obligatory or mandatory. I am not necessarily in support of that. The origins of widespread acceptance of mediation in the United States has been that it's voluntary all the way through. Now, mediation has been so successful on the part of those parties who voluntarily chose it that other people, notably courts, have said it's such a good idea, let's make it mandatory. But that doesn't follow, I think. So we have had some jurisdictions, some courts, that have decided to make it mandatory. And it is true that sometimes parties in disputes who are obliged or forced to come to mediation against their will. Once you get them there, they might settle in mediation. It happens. It doesn't happen as often. They are not as happy as when they come voluntarily. So I think there is a danger of undermining and spoiling a good process by making it obligatory. I'm not in favor of that. You can support mediation, encourage mediation, educate people about mediation, make it available to people. That's a lot different from ordering people to go to mediation. The processes that Ken Feinberg described, these very unique tragedies that Ken Feinberg was involved in, were not true mediatory processes. They were special claims evaluation processes. The government set up the money for the 9/11 fund, and Ken Feinberg did the difficult, splendid, wonderful job of allocating that among the victims. BP was forced to put up $20 billion, and Ken Feinberg did the wonderful job of allocating that among claimants. Same thing in Agent Orange. The kinds of cases that Carmen Reese and I do are quite different because there may be a contamination, a spill of something. But nobody's there to make the responsible party put up any money. Our job, the kinds of cases we have to do, require us to voluntarily get the responsible parties to agree to put up the money that will compensate the victims. And that is a pure mediation function. And we've done it in drug cases, pharmaceutical cases, environmental cases, widespread personal injury cases, construction cases, every kind of case possible. And for those to work, I believe the parties need to come to the process voluntarily, engage in the mediation process, and come to a voluntary resolution.
I share Eric's concerns about making mediation mandatory as opposed to voluntary, and I would add just 2 points. One is the importance of the change in mindset that happens when parties come to the mediation table voluntarily. There is a change from wanting to fight to wanting to find a solution. And I think if parties have been brought to the table involuntarily, it's much more difficult to achieve that change in mindset, which is so important to the success of the process. I think also there is an issue of timing in mediation. And there are good times and bad times for a conflict to come to the table for a mediation process. You need to have the right people there. You need to have the right information brought out. Sometimes it may be important to engage experts in a particular field, whether it's construction or environmental science or financial analysis. And if those pieces aren't in place at a point when parties are forced to come to the table to mediate, it's very difficult to achieve a good result. I would be heartily in favor of preserving the voluntary nature of mediation.
Thank you, Carmen. Там был еще один.
There was another question.
I have a question to our foreign colleagues. So I'll speak English. My name is Sergei Slagoda. I'm advocate of St. Petersburg Bar and since this year mediator. Dear colleagues, do you see the future of the mediation in Russia in disputes where foreign and Russian parties involved? Thank you.
Absolutely.
Безусловно, я уверен, что когда у нас происходят такие межнациональные споры, отчасти как раз проблемы возникают
of a forum, one forum or the other, differences in culture, differences in social values, differences in language. I have mediated cases between Russian parties and non-Russian parties before. I mediated a case between a Russian bank and Paribas Bank, a French-Belgian bank, and we did it in Milan, Italy, a neutral site for everything. And it seemed to me that these kinds of disputes provide an opportunity for both parties to resolve their dispute without all of the problems that a coercive adjudicatory choice would entail.
I agree, and I would also add that cross-cultural disputes offer an opportunity for co-mediation with mediators from the different cultures that are involved. It's not always necessary, but I think sometimes it can be very, very helpful to have involved in the mediation someone who understands the legal systems with which each party is familiar and understands the cultural differences that may exist in terms of how people go about negotiating and how people hear things that are said.
Thank you very much. I have one comment, but in case, let's say, a Russian mediator is qualified enough, so probably it's not necessary to attract a co-mediator. What do you think?
Well, I think you have, I know you have at least one excellent qualified mediator here, and I'm sure there are others. Besides that, I think there are lots of people out there who have the skill set, and they don't know yet they're going to be great mediators, but they can be. I have co-mediated with many people over the years and have never had a bad experience. And if it's someone who's newer to mediation, but has a particular skill set that might be useful, maybe a knowledge of French law, or maybe a Chinese law expert in Hong Kong. Even though they may not be experienced mediators, we have worked together very well and to, I think, complement each other and make the most of it. So I would not give up on the idea of co-mediation, even if the co-mediator may not have as much experience yet. And besides, it's a great teaching opportunity to enhance the skills of both mediators. You learn from each other.
We said that we have only 2 people asking questions. I can see that I will break my own rule. I saw you putting your hand up. I think that everyone will have a chance to Felix Prozorov. I'm a lawyer from Germany, from a German firm. I have a short comment. We've been talking about obligatory mediation. I wanted to share a German experience. In Germany, state courts, in some cases that they choose, some claims that they choose, they offer the parties to make a stay and resolve to mediation. It has normally to do with cases when courts see that the claims made by the parties are not really the issues that the parties want to resolve. Sometimes it is only part of a bigger conflict, or third parties are in play. And then the parties are explained why mediation will be advantageous, and they can use mediation. I think it's one of the ways how to make mediation more popular without making it obligatory. And my question is as follows. I resolve disputes in commercial and corporate sphere. My question to the Russian colleagues, where does Russia stand with mediation I can see that there's been a great success in adopting a law, but at present, what is the real status? Are parties willing to resolve to mediation in commercial and corporate disputes? Thank you for the question. Well, first of all, the parties have every possible opportunity to mediate. Well, since the law has been adopted, there are more corporations claiming mediation. But it could be more. I have mentioned that the National Association for Mediators has been established by Trade Chamber and Russian Association of Entrepreneurs. You can understand that we're still working on informing corporations and larger companies is still going on. And as my colleagues often say, my foreign colleagues say, well, you can bring a horse to the water, but you can't make it drink. In our case, it's an elephant we can't bring to the water. I think what we need to do is to make parties try mediation as a method or as means of being an international mediator. I can say yes, our parties are sometimes cautious about using anything new. I'm not opening your eyes to anything unusual. People are very careful about it, very cautious. They are. Even when both parties are Russian, for example, in the West, they prefer to have a Western mediator or a mediator who works for an international organization. As for our local experience in Russia, it's mainly small and medium-sized businesses who turn to mediation. Big business prefers to mediate their disputes, to resolve their disputes, prefer to do it abroad. Being a JAMS mediator, international mediator, examples given by Carmen and Eric, in JAMS we often face a situation when a cultural facilitator, a mediator, comes from a different judicial background and from a different language background. As for mediation being obligatory, yes, Germany has gone a long way. Since the beginning of the century, it has launched pilot projects, but it's not obligatory in Germany as well, because it's for the judge to decide whether to stay the process and resolve to mediation. It looks a lot much like a situation in the Netherlands, when the judge sees that the conflict goes beyond the court situation, the courtroom situation. It can be a conflict between individuals. In 90% of the cases in the disputes that are driven to legislation, there's an emotional moment involved, and then the judge recommends that mediation should be implemented. We do wish to make it voluntarily rather than obligatory. Even if we have to introduce it as obligatory, we still leave the decision to the parties to make up their mind, to make the decision. They don't have to adhere to any of the decisions. They have to monitor, to control the decision-making process, and to make it not damaging and to make it easy is to inform the parties of the mediation in the courts, not the way it is done now. Now we're saying that both in the arbitrary codes and criminal codes, that we have an article, a clause that makes the judge to inform the parties. However, we're talking about a different type of information, when the judge understands the core, the essence of the procedure he's going to offer, and to held to hold those kind of information training sessions in courts to inform the judges themselves. We're not trying to make all the parties to agree to mediation, but it could enlighten and educate all the parties concerned. And next time when they make claims, they would probably turn to something else.
Really long.
I almost think that we might advance mediation even more if we made it a special voluntary thing that became known as what the most successful companies, the most successful institutions, the most successful corporations use. Make it special, a kind of secret sauce, a secret ingredient that others want to copy rather than telling everybody it's good for you, you must do it. I think it almost spreads the word better if you have a cadre of very passionate, enthusiastic users of mediation who have really benefited from it. It will catch on. It might take a little bit longer, but it will really grab more people if they follow by example, I think, rather than being forced to do it. Now, that being said, you have to have it available for people who want to do it. So if you start, if it catches on, and people in run-of-the-mill, normal cases, not unusual cases, but everyday types of cases, want to use mediation, as I think they will, because I think it is an inherently better process for many disputes, then it's the responsibility of the bar, of the legal association, of the mediators association, of the state to support it, foster it, educate, encourage. It should be taught in law schools, in legal education. It should be taught in business education. Of course, there should be judicial conferences on it so that they understand it. But a danger, of course, is that it could be set back. It could be crushed by well-meaning officials who don't really understand the voluntary nature of it. And so that's a danger. The other thing, there's another danger on the other side of the coin. The other side of the coin is that if you blend mediatory processes and judicial processes, you might undermine, actually, the judicial process. You might confuse the judicial process. The judicial process, at least in common law countries, and I think the same in civil law countries, has certain principles, procedures, rules, proofs, evidence, and hands down decisions in a certain way. If you start inserting mediatory processes in the adjudicatory process, you are going to dilute the adjudicatory process. So I think it's important that while they support each other and complement each other, that we remember that they are different processes. I start out every mediation by reminding the parties that this is not arbitration light. It is not a weak form of arbitration. It is an entirely different and separate process, not to be confused with arbitration or adjudication. When I arbitrate, I have the power. I have all the power. I find facts. I make conclusions of law, and I hand down an award that is binding. When I mediate, I tell them I have no power. And I'm proud to tell them I have no power. And I say to them, well, you must be thinking, what good am I if I have zero power? And of course, the answer to that question is that the wonderful success of mediation is that the mediator has no power. He or she can't hurt the parties. He can be biased, he can be incompetent, he can be having a bad day, but he can't hurt you. And therefore, when people are with a mediator, they are with a neutral person who is passionately devoted to helping the parties resolve their dispute, but he can't hurt you. There's only one direction he can take the parties, and that is up. So that is a fantastic opportunity that does not exist in court or in arbitration. And it's very important to maintain the distinction between mediation and these other processes.
Разрешите небольшую ремарочку?
May I throw in a brief remark here? This has to do with the German experience and the German practice in general. I would like to say that in Russia, for those experts who deal with these issues, mediation is nothing new. For about 20 years, Russia has been developing this institution. We know that there is some training going on the basis in law schools. This used to be a very small specialized field, but now it's widening. We now have not really dozens, but hundreds of mediators which have been trained, which meet all the professional requirements that are established by the law. I would like to also talk about practice. Yes, we do have an army of mediators, but not all of them are demanded. But then there are other types of mediators. For instance, I have a mediator in Rostov where he is right now dealing with some 40 cases, 40 disputes. So I don't think we should be saying that the process is really in its infancy. Well, yes, indeed, we should be modest, but we've gone through so many stages and we have acquired some capacity, and we're doing a lot of implementation, really. So, yes, sometimes it's all implicit. It cannot be observed directly, but starting this year, the centers, the mediation centers, have started publishing their reports, and we have mediation centers not only in Moscow and St. Petersburg, but also in Ekaterinburg, Rostov, Voronezh, Novosibirsk, and other places around Russia. So my observation is that the ball is rolling, and given the potential to introduce an obligation to inform about the options, and I would even continue after Cesana and say that sometimes it could impose an obligation to at least try mediation. So this mandatory requirement has potential. It shouldn't be because there is no harm in trying, really. This is one way forward. I have another question, and I think it's pretty pertinent. It was a long time ago. The Duma hosted a roundtable on mediation. It was chaired by Cesana, and one issue that was raised was about mediators' liability. The chair of the Russian Insurers Association spoke, and he said that they were prepared to incorporate mediation, meaning they can consider providing some coverage, insurance coverage, to mediators. But then he said, if we are to do this, we need some standards. We need some standards, some criteria, for instance, for defining an insurance event. So his question was, can you think of any mediation standards? Of course, it's given the voluntary character of these procedures, this is probably too much to ask. Well, thank you very much. This is a pertinent question. Indeed, the issue of liability is highly relevant. The law has Article 17 on the mediator's responsibility. And it was introduced under a lot of pressure. We were forced to do it because it's controversial, and I think Eric Green and Ms. Rice will also contribute here, but the international experience shows that there is no such thing as mediator's liability other than professional misconduct, ethical misconduct. We have raised the question of providing possible insurance coverage to mediators more than once, but even lawyers are not fully covered these days. I think we can only speak about singular cases here. Of course, this is some food for thought for the future, but for a start, we already have a code of conduct for Russian mediators. This could serve as an important jumping point for developing this question of liability further. So we have the fundamentals established already. Perhaps Eric and Carmen could contribute or continue answering this question. So what about mediators' liability? How is that dealt with in the United States?
We do have insurance, and we've had insurance for our entire mediation careers, and we've never had a claim on our insurance, nor are we aware of any mediators who've had claims. I think that in general, because, as Eric said, the mediator has no power, there's not so much wrong that the mediator can do. The mediator can breach confidentiality. That could give rise to liability. The mediator could fail to disclose some sort of conflict of interest, and that could give rise to liability. But other than that, I don't think that we really see much in the way of mediator liability. It is a concern, especially in the litigious culture that we live in the United States, that, of course, lawsuits are possible. I would say the only time we found ourselves in court twice defending subpoenas where somebody outside of a mediation wanted confidential information that was part of a mediation that we had conducted, and those are the only times.
Yes, I am not aware of a single instance of a mediator in the United States having to pay anything for professional negligence, and that's in the one case where I'm aware of where a court questioned the behavior of the mediator. The court said that it would be impossible to find causation, that the mediator had caused any damage, because it's up to the parties voluntarily to decide whether they want to accept a settlement or not. This was a classic case of a woman who had gone through a divorce with a mediator. And after she was divorced, she was sitting around the swimming pool talking to some other divorcees, and they were comparing their settlements. And she became unhappy with what she had received in her divorce when she heard what the other ladies had received, and she decided she'd blame the mediator for mediating a settlement that was less than what she now thought she should have. And the mediator was perhaps not that competent as a mediator in that situation, and maybe didn't perform up to a minimum standard, possibly. But the court said it'd be impossible to find any causation on the mediator. So it's very unlikely. It's possible. We have insurance. It's very inexpensive because there haven't been any successful claims.
Tisana, it occurs to me there's one thing to add there. In the United States, one can get in trouble for practicing law if you don't have a license to practice law. And there have been occasions when mediators who are not lawyers have been accused of practicing law without a license. We have provisions in all of our mediations are conducted pursuant to an agreement that is signed by the parties that spells out what the process looks like, what the obligations of the parties are, what the obligations of the mediator are. And in that mediation agreement, we have a provision that says we cannot and will not provide legal advice to the parties in the course of the mediation. And that is a provision that's actually required by our insurance company.
But let me add a couple things to that, okay, because Carmen raises some very interesting points. First of all, we are lawyers, highly trained lawyers. We practice law. But we believe that the practice of mediation is not the practice of law. We take that position very strongly, and we believe that there are very good mediators who are not lawyers, and we don't want to do anything to shut them out of the mediation process, especially for certain types of disputes. Non-lawyers may actually be better than lawyers. So let's not jump to the conclusion that it's the practice of law. The other thing is, when we mediate, although we do not give formal advice on the law, very often in the types of disputes we are called upon to mediate, the parties ask us for our feedback, our realistic assessment of the strengths and weaknesses of both sides. We will engage in that with them. This is called evaluation. If they ask, we will engage in that, but we do not consider that giving legal advice. The other thing is, in my personal practice, I won't mediate with parties who are not represented by lawyers. There are plenty of mediators who do, who mediate between parties who come without lawyers in certain types of cases. But I never do that, so I don't have to worry about representation.
Does anybody have questions regarding liability? Well, in that case, your turn, please. Vladimir Zagvedinsky, I'm Vice President of the Scientific and Methodological Center Mediation and Law. Not a long time ago, in Russia, a group of mediators expressed the following proposal quite vocally. They suggested that the main development avenue for mediation in Russia should be towards creating a system of state-run conciliatory centers. This is how they saw the path forward for mediation in Russia. What do you think about this proposal?
You know, I think it may depend very much on your culture and your system, and I'm probably not really competent to express an opinion grounded in your culture and political system. But generally speaking, I say let 1,000 flowers bloom. Let the state create some centers if it wants, but let private mediation organizations develop and allow both and see what people like and see what works. At this point, I say the same thing about standards, mediation standards. Mediation is so flexible. That's one of its great strengths. There are different ways of mediating. I know there are people out there who mediate differently than I do. Carmen, I've watched her mediate. She mediates differently than I do in some ways. It's still such a young field. It's too early to rigidify any one set of standards beyond confidentiality, respect, and no conflicts of interest, because you're going to limit possible good practices, and you will limit the flexibility of the process. As soon as you set a rigid standard for mediation, I'm going to go out and I'm going to invent a new process that's better, okay? Because I want the flexibility to adapt the process in each case. And I want there to be state centers, fine. I think, I don't know, maybe they could be abused, but generally speaking, as long as other forms of delivery are not prevented, let 1,000 flowers bloom.
I would have to agree with that and also make the same qualification that I don't feel nearly familiar enough with the Russian system to really be entitled to have an opinion. But I think the problem comes in not in having a state-sponsored system, but in requiring anybody to use any particular system. And that as long as there remains choice, I don't see a problem. We have in the United States some court-referred processes where the mediators are under the auspices of the court. People are free to use those. They are not required to. We have the Attorney General's office in our state of Massachusetts offers a mediation program for consumer disputes. People can use that if they wish to, but they aren't required to. We are private mediators, and there are hundreds, probably thousands of private mediators in the United States that one can employ if one wishes to, but you're not required to. And you may want something different for different disputes. So I think really the keystone is choice.
My name is Tatiana Zakharzhevskaya from St. Petersburg. I'm a lawyer and a mediator and a member of Mediators League. As a practicing lawyer and a mediator, I have some practical information. First of all, I would like to answer our colleague from Germany. How do you find mediators in St. Petersburg? We've had it for 20 years already. As a colleague of mine from an arbitrary court magazine, it's St. Petersburg University, which runs 2 educational centers. One trains mediators, and I think this program is very strong. I think it's a better program than the government has established. And another is conflictology service, and mediators can work there before they start working on their own. This league brings together 76 members, and to be a member of this league, you have to answer to certain high requirements. Since 2008 in St. Petersburg, we've been running a pilot project together with the Judges Council. We started to work in local courts, in regional courts. Arbitrary courts are also ready to work with us, but we're still a bit slow on that. What do we face in reality, and what we find we need from the federal legislation or regulation? The first issue is information, or people being informed, population being informed, and judges being informed. And as Susanna said, it's not the judges. Judges do not only have to offer mediation, but explain what it is about. And also the bar being informed. They either try to prevent mediation because they are afraid to lose their jobs, or they misconduct mediation when they begin to represent one of the parties. Another issue, another problem we face has to do with the lack of regulation of norms that regulate relationships between the judges and the mediators. The judges do not understand whom they invite, how do parties report. In St. Petersburg, answering the request of the Council of Judges, we are preparing this kind of these kind of regulations, but so far we're in their early stage. People are still unaware of this mediation process, and a lot depends on the judges providing information on where to find mediators. How will the judge know whether mediation process has been concluded, and what are the requirements for the procedures of coordination between mediators and judges? And the third problem has to do with the categories of cases. The dispute on private claims, they are very easily resolved through mediation. This minor criminal claims, nobody wants them, and people are ready to reconcile. But after this law has been adopted, unfortunately, this procedure has avoided the course. It's difficult for the courts to involve mediators in minor criminal cases. And I think we have to draw a line here. And I have a question to our guests. Do you have any regulations for interaction between courts and mediators in the U.S.? Do you have any legal norms that regulate?
this is what you were asking, but in the standard operating procedure, the rules are pretty clear that a judge may not inquire of what happened at a mediation. And a mediator is obligated to maintain the confidentiality of everything that's said and done in the mediation process from the court, so that parties don't fear engaging in mediation in some way, because what they do or don't do will be reported to the court. So in the standard case, we have that separation. Now, in the some courts, as Carmen Reese mentioned, have set up referral programs where the administrative judge of the court perhaps is in charge of overseeing a program that might be offered as a choice. In some places, even you're required to try it first before you come back to court. And in those situations, generally the courts have certified mediators and standardize them, and they make their names known to the parties. Parties, of course, are always free to pick their own private mediator instead if they want. Very often there's informal exchanges of views on the process between mediators and judges. I know a lot of judges, and we're at conferences together. I'm sorry. I know judges were at conferences together. Should I wait? Okay. And they know me, and we exchange views about mediation and how it can work, and in what kinds of cases and things like that. And those are very good. That's good dialogue. And the judges recognize the mediators as other neutrals, like they're neutrals in the system. We're all a little bit different from the practicing lawyers who every day are on one side or the other, Simon's position. So we have some kind of community of interest. But again, that separation in a particular case is very important to maintain.
I think the other source of rules, other than the confidentiality requirement that exists in the mediation process, would be, for us, the judicial code of conduct. There are ethical standards for judges that would prevent certain kinds of contacts by the judges with mediators. I can't give you particulars there, but that would be the place where we would look for that.
One danger, of course, where you have judges and courts very involved in mandating mediation and sending people to particular mediators, is cronyism and corruption could infiltrate the system. And always have to be on guard against that. And we have the same problems in the United States in that respect as you do everywhere. So that's another reason to maintain some separateness.
I have a question that refers to the settlement, how the settlement is fulfilled. In the Russian Federation, according to the law, the settlement that has been reached through mediation is not mandatory for the parties to be fulfilled. It is fulfilled on a voluntarily basis. It can be fulfilled, it cannot be fulfilled. So if it's not fulfilled, the parties go to court. While fulfilling those settlements in the U.S., is it mandatory for the parties or is it not?
Very good question. Most settlements in mediation are memorialized in a settlement agreement, which is a contract. If some party does not implement the contract, you have to go to court on a breach of contract to force them to implement the settlement. So, but the the huge hidden economic benefit of mediation is that 99% of the time, a mediated settlement is voluntarily implemented. However, when you go to court and you win a judgment, that's just the start of the process. Because when you win a judgment, you've got a very unhappy party who's lost. They're going to do everything they can to hide their assets, to appeal, to prevent the collection of the judgment. But when people agree in mediation, they implement it 99% of the time. The huge savings are on the back end of the process, more than on the front end of the process. So it is true that it's possible for a party that signs a settlement agreement not to fulfill it. It's very, very unusual in mediation because they voluntarily agreed to do it.
I would add that there are some circumstances where parties are very concerned about having a settlement paid, and I have seen people do things like, for example, both Eric and I have held money in escrow for parties pending perhaps signature of settlement documents or what have you, at which point we would turn over the settlement money. I've also seen people do things like agree to execute a judgment, which would be something that would, it would bypass the whole litigation process of complaint, answer, and so forth, and instead you just get the piece of paper, which is the judgment, and we've held those in escrow for parties, so that in the event a settlement is not fulfilled within a particular amount of time, that we would release that document and that party could go straight to court with it and then go ahead and enforce. Those are very unusual circumstances because, as Eric says, typically people are so delighted to have their disputes resolved that they just want to get them behind them and fulfill whatever they have to do. So it's the rare case rather than the regular case where we would see those kinds of measures taken.
We are still holding in escrow money deposited with us about 20 years ago in an environmental contamination case where the cleanup was to take 15 or 20 years, and we're still holding that money in escrow. And as far as we know, it's the only investment that we know of that did not lose money during the financial crisis because we had it invested in extremely safe investments. So that's another benefit of mediation.
Спасибо. И вы хотели что-то добавить?
To add something. But I still don't get it whether the settlement is fulfilled on the voluntarily basis. If you don't want to, you don't. So it's not mandatory. In the Russian Federation, we have a system that ensures fulfillment of certain damages, for example, awarded. Do you go to the court again, presenting all the proofs?
That's the problem, again and again and again and again, even if you've got a judgment. But in mediation, if they settle, why won't they fulfill it? Why would they settle if they're not going to fulfill it? So as a practical matter, it's much more likely that you get what you agreed to than you get what you win if you go to court. My first case as a lawyer, we have these processes too. My first case as a lawyer, I won the case. I got a damage award against a party. I could not collect it. I did everything I could to collect it. I went back to court so many times, and I put the constable on them, and we searched for their assets and couldn't collect it.
Спасибо вам за то, что вы так настойчивы.
Thank you for being so persistent with your question, because it's this question is constantly asked, especially in this country, because I don't want to hurt anybody. Nothing personal. Most of the people do not understand the essence, the core of the mediation settlement or contract. People who know what mediation is about do not have this question. You have, well, like 10-15% of mediation processes which do not result in resolution. Your context can change. Someone could make the settlement voluntarily, but something has changed. But 85% of mediation settlements are fulfilled voluntarily, and it's not a miracle, it's human logic and pragmatic considerations. If people took part in mediation voluntarily and resolved their dispute themselves, their own interests taken into account, why would they resent those decisions? Well, the dispute solution in litigation is different. Settlement is a form of settlement. It's a kind of a settlement that happens within litigation. When the parties reach this agreement, well, they reconcile, that is brought to life as a court settlement. But the nature is completely different, and the quality of this reconciliation is different. Why do I keep advocating for mediation? We're not talking about conciliation. We're talking of mediation. It's a different procedure, of different nature, and the settlement is reached through a different process. We have this mechanism switched on. We have a settlement, it should be fulfilled. To fulfill it, we need a third party or constables, for example. We realize that only 50% of judgments are being put through, are being actually awarded, or well, in family matters, it's true, but when corporations agree, no mic, unfortunately, no mic. It's another question. I was talking about this 10-15%. Well, we still have them reserved for these cases, for family cases, for example. But we need to have people at the right people at the table, competent people, people with the right authority to make decisions. No mic, unfortunately. So if it's not, well, this mediatory settlement is not fulfilled, you should not go to court again with new claims to go through the whole procedure again. If one of the parties does not fulfill an agreement, then another party has a right to go to court and get it mandatorily implemented. And here we have a loophole. Why should people go to a mediator wasting their money while another party may or may not fulfill it?
I think I need to give Eric an opportunity to answer, but let me say on my behalf, you should come and learn about motivation, because mediation, because otherwise this is a totally pointless discussion, because we have different experiences and different perspectives.
Let me give you a couple examples. I ended up mediating a series of lawsuits worldwide between two very large chemical oil companies. I was mediating worldwide lawsuits between chemical and oil companies where the dispute was over the additives in the lubricating oils worldwide. They had so many lawsuits, they had to give them numbers because they had Japan 4, Ohio 3, so forth. They had been in litigation for 20 years. I don't think anybody had actually collected a penny over these 20 years. They were constantly fighting, okay? They thought it was impossible to settle. We found a way, starting slowly. We settled all of them. And that settlement was completely complied with, okay? So superior to their litigation process. In the family area, I read a study, I don't know if it's true here, but in the U.S., if you have a fully adjudicated divorce, in other words, you have to go all the way through the judicial process and get a decree of divorce, the average number of court appearances after the decree of divorce is 90. 90. Fights over the money not being paid, custody, children's vacations, they'll fight over everything, okay? Whereas a mediated divorce oftentimes never go back to court because people have agreed voluntarily. So it's really different. So I know you're worried, but I think you're worried for the wrong reason.
Я не про семейные отношения говорю.
I'm not referring to family disputes really here. Well, you see, there is a multitude of very similar issues out there, simply because this is a new topic for our legal community and for Russians in general. I only hope that this is not the last in a whole series of meetings where we will continue discussing this. But of course, rather than discussing, we should be building more practice and base our opinions on practice. Let me tell you this. Yesterday, in many of the plenary presentations, we heard that some people were unhappy about this, some people simply stated this, that especially against the backdrop of globalization and the intertwining of different... It's okay. Can you hear me? So, a lot of people said that there is tough competition going on between different legal systems against the backdrop of globalization. And I think that mediation has a place here, and many people made a very strong point about this yesterday. Perhaps currently the Russian legal system is somewhat somewhat lagging behind in this competition. So perhaps we should try to encourage the courts to contribute to the development of mediation as an alternative dispute resolution mechanism. However, they should encourage free development of ADR, because mediation is also a way to counter corruption. That's another important aspect. We didn't have time to discuss this today, but we know that in this country it's one of the most troubling social vices. And sometimes we see draft bills being put forward to the effect that we should have judges acting as mediators, or we should have court staff acting as mediators. I don't think this is the way to go. This is too bad, because in this case our legal system will lose completely this competition, and all businesses will simply leave this jurisdiction. When we were negotiating mandatory mediation for a series of types of cases, the businesses are strongly opposed to that, and quite understandably so, because they want voluntary choice. They want freedom to choose a mediator. That, yes, mediation does work for businesses, but it should be freely chosen. So there are a lot of different dimensions to this topic. Some people might think that this is really a lightweight pretty straightforward procedure, nothing convoluted here. It's just a way of settling business disputes. But they seem to forget that it's a highly pragmatic institution. This is an institution that is used by those people who really strategize about their businesses, people who really have a very good legal strategy for their activities. I think mediation is also demanded very strongly given the social trends that we see around the world, because whether we like it or not, we have to be able to come to the negotiating table. But of course, it's one thing when you are forced to negotiate, when you are pressured to negotiate. It's quite another thing when you can do it voluntarily. Therefore, I do hope the potential of mediation will be unleashed. I want to thank our guests who have about half an hour before they leave for the airport and they need to drop by the hotel. I'm thankful to Carmen and Eric for coming here today. I do hope we will continue taking our cooperation forward. I want to express my appreciation to all of you for a highly interesting and hopefully enriching, informative discussion, and I do hope it will contribute to the development of mediation in this country.